Good afternoon and welcome again to another conversation on policing and racism. And today we have a very insightful author of a book called Junk Science and the American Criminal Justice System. However, before we start with that, we always do our CSUSB land acknowledgement. My name is Cecilia Smith. And here we go. We recognize that California State University San Bernardino sits on the territory and ancestral land of the San Manuel Band of Mission Indians. We recognize that every member of the California State University San Bernardino community has benefited and continues to benefit from the use and occupation of this land since the institution's founding in 1965. Consistent with our values of community and diversity, we have a responsibility to acknowledge and make visible the university's relationship to Native peoples. By offering this land acknowledgement, we affirm Indigenous sovereignty and will work to hold California University San Bernardino more accountable to the needs of American Indian and Indigenous peoples. I'd like to just briefly thank our technical staff, Finley and Anthony Escoto, for helping us out today. And I'm going to pass this over to Mary Texera, sociology professor emeritus, and she's going to introduce our special guest today.
Thank you very much, Cecilia, for that warm introduction, as well as for the land acknowledgement, which we do every week. I want to thank our guest, Chris Fabricant, for joining us today. I'm assuming you're on the East Coast today, Chris? Okay.
Yes, indeed.
But unfortunately, you all are having similar weather to us in California, which is not good news for the environment. But anyway, enjoy it while you can, I suppose. I'm so excited, and I think our audience is in for a real treat in terms of, most of us are into true crime, and we're fascinated by what we see on television, and there's even television stations, whole networks that are devoted to true crime and forensics. And so I'm hoping that you will find something that you can identify with in this talk today. I'd like to, first of all, let you know that the Q&A session is indeed working today. So if you would like to ask a question as we're in the middle of the program, we'll try to get to them at the end of the program. Our guest today is Chris Fabricant, who is the Innocence Project's Director of Strategic Litigation. And I think, Chris, maybe you should start when I'm done with the introduction, letting the audience know what the Innocence Project is, because I don't think we talked about that. As one of the world's leading experts on forensic sciences and the criminal justice system, Chris is uniquely qualified to discuss this controversial topic. His public commentary has been published in every major media outlet. He's a former public defender and clinical law professor, and brings to his writing over 2 decades of experience, ranging from litigating death penalty cases in the Deep South to misdemeanors in the South Bronx. And I have to say that I absolutely love this book. A lot of the textbooks that we read, unfortunately, and you're all in the middle of that right now, are pretty dry, and you don't get emotion. And that's not the case with this book. He's a beautiful storyteller. His voice is sober, but with passion. He deconstructs this so-called science that we all hang on to. But the impact of junk science on real human beings really comes across in this book. This is a story of prosecutorial ambition tainted by racism, though not always, using bad science to warehouse and kill innocent people, using cover-ups and incompetence from the FBI to the small PDs around the country. In reading his book, I was reminded of the series of experiments that were conducted at the end of World War II by a number of social psychologists, one of whom was Stanley Milgram. Milgram did this study, and I'm sure most of the people in our audience know this study because it's in Psych 101 books. But he did a series of experiments to test obedience to authority coming out of World War II. This was how did the German people ... or how did people in Auschwitz ... So why is it that people were so willing to obey? And he found, he did a series of experiments pretending to electrocute someone. And so these experiments were, they had predicted that 3 to 4% would obey all the way, but in fact it was 80%. And they were much more likely to obey if the person telling them to do this experiment, if they were telling them if they were in a lab coat. So that said to me that lab coat signifies what? It signifies science, right? And scientific. So when you call something science, courts, juries are much more likely to believe you if you have that lab coat on, or if you say science. So without further delay, I give you Chris Fabricant, and we'll start with asking him how he got into this line of work. And, because we like origin stories. Some of us are still trying to figure out how we want to find ourselves in the world after graduation. So I think just very briefly, Chris will talk a little bit about his own trajectory, as well as give us a statement of the thesis of the book. Chris?
Hi, thank you so much for having me. I am delighted to be here. I wish I was there in person, but I am delighted to meet you all online. I've really known, or I knew most of my life, that I was going to be a criminal defense attorney. I think it goes back to a drug bust in 1969 that my mother was indicted for trafficking hash, and my dad was a public defender and was assigned to her case. And that's how they met. So, it's kind of an origin story. It's like from that moment forward, kind of always knew that I was like kind of a product of the drug war, and that the first book I wrote was about the drug war. And I kind of always knew that I was going to be a defense attorney. And I started as a public defender at the appellate level, and then I moved to the trial level. And I think the reading that I'm going to give talks a little bit about that. And then I was a clinical law professor for 3 years before I went to the Innocence Project. And for those of you who are not familiar with the Innocence Project, we're having our 30th anniversary this year. And really around in 1992, with the advent of forensic DNA analysis, which was an earthquake in the criminal legal system, that the Innocence Project opened. And Barry Scheck, for those of you who are older in the audience will remember from the O.J. Simpson trial, was one of his attorneys, and Peter Neufeld started the Innocence Project. And what was really important about this, not just that they were freeing the innocent, but what it showed was, and this is really related mostly to the intake criteria of those who were seeking help from the Innocence Project. And really what it was that they were going to make no subjective judgments about guilt or innocence, and that the only criteria that we were going to consider was whether biological evidence, if it could be found, DNA evidence, if it could be found and tested, would that prove innocence if it came out, a certain way. And because of that, society learned that our jury system is infinitely more fallible than we believed, and that wrongful convictions are not a 1 in a million, but occur with some frequency. And we learned that, for example, we had many cases where you had multiple eyewitnesses, up to 6 eyewitnesses, all claiming that our clients were the perpetrator, and turned out to all be wrong. And we also learned, as a result of this kind of new way to litigate and post-conviction, that junk science was responsible for at least 50% of all known wrongful convictions. So all these techniques, including DNA and fingerprint evidence and bite marks and hair microscopy and shaken baby syndrome diagnoses and arson evidence and polygraph evidence and shoe print evidence, all of these techniques have been led to wrongful conviction. Many of them are entirely junk science. Many of them just can never be done reliably, or sometimes you just have low quality evidence. So those factors, so eyewitness identification, junk science, false confessions, is another thing that we learned that nobody ever believed before, was that innocent people would confess to crimes that they hadn't committed. Detailed confessions, including apologies to victims that they hadn't victimized, right? So all of this was shocking. And about 10 years ago, I was hired to start a new legal department at the Innocence Project called Strategic Litigation. And what we do is litigation around the leading contributing factors to wrongful conviction, which I just told you about: eyewitness identification, false confessions, and junk science. And my role, apart from running this department, is the forensic science litigation. So my work in this book and these stories is related to my work. And what the book really attempts to do is it's a new genre. It's untrue crime, right? Is that we're trying to undo the misinformation that so many of us have gotten from shows like CSI and Forensic Files and everything else. I am so sorry, but there is somebody at my door. My apologies. I will be right back.
Cecilia, can you show us yourself if you're not busy so that we can have a little bit more of an audience? Thanks.
My apologies. Shh. My apologies. So what this department is aimed at is eliminating the leading causes of wrongful conviction. And my book goes into the development of how junk science first got into court, why it's been so hard to get rid of, and it tries to tell the history of junk science through the lens of three of my clients' cases: Stephen Chaney in particular, Keith Harward, and Eddie Lee Howard. And the passage that I'm about to read is my first meeting with a first Innocence Project client, in that I had never represented somebody like this before. I had never had any clients at the Innocence Project before. And it was really after this meeting that I understood that I was going to have to write this book, and that I was having these experiences that I wanted to share with a wider audience, because most people don't understand that this goes on and why and how. And so I'm going to read from my book. Interstate 45 originates in the southeast corner of Texas near the Killing Fields, a 25-acre patch of dirt outside of League City, where the bodies of at least 30 victims, nearly all young women thought to have been murdered by multiple serial killers, have been found since the 1970s. The highway runs a straight line north from League City through Houston before petering out in Dallas. The featureless terrain is so flat I could almost see Huntsville 65 miles away from my rental car as I headed north out of the Houston airport. An hour later, I passed the 70-foot-tall statue of Sam Houston on the outskirts of Huntsville. A white school bus with wrought iron mesh covering darkened windows passed in the southbound lane. The Texas Department of Criminal Justice's sky blue seal stamped on its side. Prisoners on the train, handcuffed to each other for grinding cross-state bus rides on steel benches, heading from one cage to another. 58,000 prisoners endure roughly 22,000 trips or bus therapy every year across Texas, covering close to 5 million miles. Forgotten people going to hidden places. I pulled into the visitor's parking lot and stuck the file on the passenger seat into my shoulder bag. The inch-thick stack of paper represented everything I knew about Chaney's case. There were some pages of transcripts, Jim Hale's and Homer Campbell's testimony, a copy of the appellate opinion, crime scene photos of the Sweeks' mutilated bodies, and dozens of the U-shaped entry on John Sweeks' forearm. Julie Lesser met me under the 3-story red brick guard tower at the front gate. Razor wire gates parted as we walked along a sidewalk, cutting through a neatly trimmed lawn to the main entrance. At the guardhouse, a corrections officer scrutinized my New York State bar card before allowing me to sign in for a legal visit. Heavy steel doors slid closed behind us with a 1,000-year thud as Lesser and I walked the gray corridor toward a row of cubicles partitioned down the middle by thick plexiglass. Black phones were mounted on the right-hand sides of the walls. There in the center booth sat my first Innocence Project client. He'd been waiting a long time. During my time as a public defender in the South Bronx, I spent a lot of time visiting clients on Rikers Island, New York City's infamous jail island complex in the East River. My clients were mostly young men bursting with rage, fear, desperation, and yes, hope. In my earlier work as an appellate defender, my clients had already been convicted at trial and were just beginning to serve lengthy prison sentences, slowly emptied of hot emotions, nurturing hope for freedom in prison law libraries in upstate New York. Most of my clients, those thrumming with pent-up energy on Rikers and those warehoused in centuries-old upstate prisons, were deeply skeptical of public defenders. Trust was earned only through showing respect and fighting hard. Usually I lost. Often I would not see or hear from my clients again after a conviction. There was always another more immediate crisis, another trial, another appeal, another arraignment shift. The wheel never stopped turning. There were thousands of individual people I represented, some for a few minutes at arraignments, sometimes for a few years, but I had never visited anyone 25 years into a life sentence. My file also held Stephen Chaney's arrest photo, a color Polaroid from the day Detective Westfalen pulled him off the construction site in Las Colinas. Deeply tanned from laboring under the Texas sun, Chaney wore a dusty white t-shirt that hugged his wiry frame. His chin pointed at the camera defiantly, exposing a prominent Adam's apple. His robust head of dirty blonde hair framed intense blue eyes. The coiled energy from that photo is pure Rikers Island. And that was not the man sitting on the opposite side of the grimy plexiglass. Chaney had been drained of color. His hair and his eyes had gone iron gray. Deep lines ran like rivers across his pale forehead and down the sides of his mouth. His dull white prison scrubs made him nearly invisible. Only the black prison-issued Buddy Holly-style glasses stood out. I sat down on the steel stool in front of Chaney and picked up the phone. As he lifted his phone, Chaney bowed his head, seemingly collecting himself. When he looked back up, tears were streaming from his eyes and rushing through the lines the wind unit had carved into his face. "See," Lester said to Chaney, "I told you he would come." None of the years I'd spent as a public defender prepared me for this. I'd never walked into a client interview and been treated like a savior, like I was wearing a cape. For the deeply religious Chaney, Julie Lesser was the vehicle Jesus had sent him, and our meeting in Huntsville was further evidence of the greatness of God. Chaney had spent the last decade watching Innocence Project lawyers free his fellow prisoners. Here was his own. In that moment, I felt an awesome responsibility. Chaney had been a test case for me until then, an ideal vehicle for using the junk science writ to challenge the status quo. I did not think about whether he was guilty or innocent. It was simply a perfect case. But now I had a client who believed I could make prison doors open with the wave of a wand. It was terrifying. There was little I could tell Chaney about bite mark evidence that he didn't already know. At his elbow was a battered copy of Scientific Evidence, a comprehensive treatise on forensics edited by some of the most respected science and law scholars in the country. Chaney knew it better than I did. He knew about footwear evidence, presumptive blood tests, and polygraphs, the throw-in junk science that was used against him. Chaney knew subtle lies and liars. He knew waiting in line. But unlike me, he knew he was innocent. And unlike me, he had faith. I tried to temper expectations. There are a lot of bad facts and no more DNA to test, but Chaney never stopped smiling during the hour or so we spent together. He knew our meeting was the manifestation of his faith. God bless you, Mr. Fabricant. I wasn't sure what to say. We pressed our hands together through the glass and I flew back to New York.
Boy, that was pretty moving. And I can only imagine if it moves us as you're reading it, how you must have felt after meeting this man who had been locked up for so long.
That's
I
great for
think
my
that,
notes that I took in
um,
my diary in the parking lot.
yeah, yeah. If you could you let us know, and I'm thinking specifically about AAFS, ABFO, and the NAS report, how we got to, thinking that these folks are gods, essentially, when it comes to bite mark and arson evidence and so forth.
So really, being a forensic scientist wasn't a career that you could aspire to before the 1960s, really, in the post-World War II era. And that was really, it began with forensic pathology, became an organized profession and started offering board certification to pathologists. The FBI crime lab was first introduced, and then local crime labs started to pop up around the country. And at the same time, and this was all obviously to support the criminal legal system. And then on the civil side, what you had was an explosion of personal injury litigation and toxic tort and product liability litigation. And on the criminal side, what you had was the buildup of the carceral state and mass incarceration, really largely driven by the drug war and some of the other kind of unfair sentencing. There are a lot of little reasons, but a largely part of the drug war aimed primarily at Black and brown communities. And what you had as a result, though, is this really exponential growth of the legal system on both the civil and the criminal side. And both were using ever increasing amounts of scientific evidence. Sometimes some of it was bogus, some of it wasn't. And on the civil side, what you had was expert witnesses that had cropped up just to support litigation, right? That they no longer worked in the field, that you could become a full-time expert witness. You could make a lot of money. On the criminal side, forensic scientists were becoming heroes, pop culture heroes. And the show like Quincy, for those of you who remember that, was a crime-solving pathologist and were lionized in the media and popular culture. Huge trials like the Sam Shepard trial, and one of the trials that I go into in some depth, the Ted Bundy trial, as it relates to bite marks, became national sensations. The Ted Bundy trial was the first nationally televised trial in the country, and these forensic dentists who had invented this whole technique of bite mark evidence were the stars. So what you had was, on both sides, this huge growth of scientific evidence being used. And the corporate bar was getting very tired of junk science being used against them to sue the pants off all these corporations. Some of it was righteous litigation. We're happy that Ford Pintos are no longer on the road, but some of it wasn't. A lot of junk science was used in those. I'm not kind of normally aligned with the corporate defense bar, but as far as science goes, they were tired of it, and they teed up a case to the United States Supreme Court called Daubert. And what they wanted was courts to apply basic scientific principles to evaluate purported scientific evidence before it was introduced at trial. And they won, and they got this new standard. On the criminal side, though, and as a result, nearly 40% increase in the exclusion of expert witnesses that were proffered by plaintiffs' attorneys in civil litigation. On the criminal side, though, nothing changed. And this was true 10 years after that decision was made. An empirical study by my boss, Peter Neufeld, showed that prosecutors were 100% successful in introducing everything that they offered as scientific evidence. Defense attorneys were maybe one time had it successfully excluded anything. And this is even after known wrongful convictions had been used, that had used these particular techniques. And one of the reasons that I wanted to explore this topic is, or what I started calling them really was poor people science. It's a term that I had explored in the book, because we really don't care about the science that's used to incarcerate and kill those who are subjected to our criminal legal system, almost entirely poor people and disproportionately Black and brown people. So this is the poor people science that we get. And how it got into court in the first time, apart from popular culture, is that you had these organizations like the American Academy of Forensic Sciences that allowed in all of these experts without vetting any particular, the science themselves or the experts themselves. It's really more of like a big club, but it sounds very sciencey. And then what you had in forensics is that these organizations cropped up that just invented credentials, board certifying. So one of the ones that I spent some time with in the book is called the American Board of Forensic Odontology. And that sounds very impressive, very sciencey, right? But it's nonsense. It's an old boys club. They didn't even test any of the abilities of any of these dentists to do what they claim to be able to do, to identify a bite mark and match it to a suspect, which is an impossible thing to do. But you could go into court, and this is what happened in the first case, saying that I'm a member of the odontology section, or I'm the chair of the odontology section in the American Academy of Forensic Sciences. I'm a board certified member, or what they call themselves, diplomates of the American Board of Forensic Odontology. And he had to call them doctor because they were dentists. And they deferred to this alleged expertise because Americans, people in general, tend to defer to anybody wearing a white lab coat and calling themselves a scientist. And so even after we'd had, it was not until 2009 where you had the first opportunity for mainstream science to take a look under the hood at what was being passed off as scientific evidence in criminal courts. And that was what you were referring to, Mary, as the NAS report. We tend to call it the NAS report because this is a report from the National Academy of Sciences. For those of you who aren't familiar with it, it's the most prestigious and important scientific entity in the United States, maybe in the world. And because forensics had been developed by these clubs or these like guild-like structures where wisdom is passed down from generation to generation, from mentor to mentee like that, kind of like plumbers, is that system doesn't incentivize questioning the received wisdom of the masters of the trade. It incentivizes learning those rules because they rely on their mentors for casework, for publication opportunities, for job titles, for all the rest. So in science, though, we have a scientific method, and these experiments are done in the lab. And you develop an experiment, you publish your results, other scientists scrutinize those results, and that's a peer review process. But forensics had not really been through that. So the first time that any major scientific organization looked at this was the NAS. And what they found, this was a stunning thing I call the 38 words that moved the junk science debate into criminal courts. And those 38 words, it's a long report, but those 38 words that I'm about to tell you really boil down to this sentence, is that no forensic technique, apart from DNA evidence, is capable of identifying the source of crime scene evidence. So you think about fingerprints, you think about what you've probably heard of as ballistics or firearms and tool marks evidence, shoe prints, bite marks, hair microscopy, what have you. All those techniques had for a century had been admitted in court saying that evidence was left by that boot, by that gun, by that person, to the exclusion of everybody else in the history of time, right? And those are still admitted today. But the NES said that all of that was bogus. No technique could do that. Only DNA was even possible to do that. But one of the frustrating things, and one of the reasons that the tone of my book can sometimes be a little bit frustrated, I guess, is that it's so hard to create change because the status quo in the criminal legal system is very difficult to disrupt. The forces behind mass incarceration are the same forces that have been behind the institution of white supremacy for 400 years of our history. This is a direct extension of that, and junk science is really just another tool propping up the status quo. And you can see how it plays out where you have really, I take cases that are good cases, right? I'm not a public defender anymore. I don't take everybody who comes in the front door. And I take cases where bad science was used, and getting courts to acknowledge that the science is bad is one of the central struggles. And one of the reasons this is that if you think about the way that law works, for those of you who might not be familiar with common law, but basically law doesn't change that much. It'll be a new precedent is established. And once that precedent is established, all the lower courts just kind of follow along, and it's pretty static. Science, on the other hand, is a process. It's always moving forward. If we have a hypothesis that's been falsified, we abandon it. When we take in new data that tends to discredit what we previously believed, we abandon those previous techniques. Law is the opposite, and that's essential tension. And so when we're trying to do this type of work, we're trying to disrupt often a century of legal precedent with a couple of scientific research studies. But those are really conclusive that show that what you've been offering for all these years has not only led for wrongful conviction, but it's also just junk science. You can't say that. So that's like kind of one of the apart from the personal storytelling in the book, it's really a history of the use of junk science and why it's been so difficult to dislodge from the justice system and the damage done.
Thank you for that, because I have been studying, writing about criminal justice and race for a long time, and even I had to raise my eyebrows sometimes because, yes, I can accept, that odontology, forensics odontology is not correct, but arson, come on, or footprint evidence, come on now. That's just taking it a little too far. So what I would like to do in this next part is just to throw out a few of those techniques that are used and to have you refute why you put them in the category of junk science. And the first one is, to segue, is the bite mark, because it was difficult until you explained it. It was difficult for me to accept that bite mark evidence is junk science, actually.
I'd be happy to, as soon as my dog starts barking.
We can have a separate Zoom for both of our dogs, because I think mine are starting to act up now. It's okay. It's really okay. Okay, so we're going to start off with bite marks.
One of the things, one of the things that when we decided to attack bite mark evidence when we started the strategic litigation department, because it's really the junkiest of the junk sciences that I cover, and it led to a bunch of wrongful convictions already. And I asked my paralegal to find every bite mark case that you could find in the country, post-conviction, prior to trial, posthumous cases, whatever, find them all. And every case that I've touched, our clients have gotten out of prison eventually. Otherwise, we're still litigating them, which is an astonishing record. Because it's not because I'm so brilliant, it's because the cases are so bad. But in reading all these transcripts, I never saw a good cross-examination that talked about really some of the most fundamental things, because that go into, if bite marks were possible, what would have to be true. And if you think about it, is that almost always a bite mark evidence is captured in a homicide situation days or weeks later, that a forensic odontologist will come in and photograph what's purported to be a bite mark. And with a living victim, an assault victim, that injury is recorded days, later or hours later. But the thing about human skin is that it's constantly changing, right? So in a live victim, that's healing, it's swelling, it's going down, it's going up. And in a homicide case, the body is decomposing and changing every minute, right? So you could have somebody whose teeth allegedly match one day and don't match the next, right? And so that was never asked. How could you match them? Imagine a fingerprint was changing constantly, right? On the surface, and you're still making a match. That's gross speculation. The other thing is that how do you know that this injury is a bite mark, right? What is it about being a dentist that makes you an expert in bite marks? The proximity to the teeth? No. And what the evidence shows is that, in fact, they can't identify reliably a human bite mark. All kinds of other things have been mistaken for bite mark evidence. Belt buckles, zippers, all kinds of things. But beyond that is the failure of courts to really even hold hearings to say, what evidence is there that you can do this, right? That you can identify a bite mark, that you can match. There's no proficiency testing. There's no idea of how often they get it right or how often they get it wrong. So what it became was, and this is the excessive subjectivity in so many forensic techniques, that allow bias to creep into their conclusions. And bias in this sense doesn't mean, although racial bias plays a part, we're talking about implicit bias, and not implicit bias, but cognitive bias. And you can take an otherwise reliable technique, something like fingerprints, and make it unreliable if you have low quality evidence and you have a lot of irrelevant case information that's leaking into the expert that will confirm what the prosecutors already believe. So I'm going to get to arson and these other things in 1 second, but I'll just give you a really example that I explore in the book to make it clear how this stuff works. Is that an experiment that was done by ETL Drawer on fingerprints, which fingerprints are generally reliable evidence if you have high quality latent fingerprints at a scene. These aren't the fingerprints that are neatly rolled, and deliberately left. These are smudges at crime scenes. Same is true with bite marks. I mean, you might have been thinking that, oh, I know what a bite mark looks like. My toddler comes home with those from daycare, right? And I see them. That's not what they look like in casework at all. So what an experiment that Dr. ETL Drawer did after a high profile misidentification of a terror suspect in the United States that was by the FBI, and demonstrated that it's not quite as reliable as we thought it was. ETL Drawer took a casework and took a group of very highly experienced, highly qualified latent fingerprint experts, and he sent them all his casework. What was clever is that he didn't tell these experts that it was their own prior casework. The only thing that he changed was the information that was included in the case file that had nothing to do with the fingerprints. It was so there was an alternate suspect, or that the suspect confessed, there's DNA evidence, or there's other things that had nothing to do with this. 3/5 of them changed their mind, changed from their original conclusions. It was a match, it wasn't a match, etc. That and nothing had changed about the fingerprints themselves, only irrelevant contextual information. So if you think about that in terms of racial bias and all these other biases and how much subjectivity is involved in these, then you can see what we get. And he did another experiment that demonstrates the pernicious effect of racial bias in these same types of diagnoses. And to be very reductive and simplistic about the experiment that was done here, that essentially what it showed was that when Black babies go to the emergency room with the same injuries as white babies, the Black babies' parents get charged with homicides and the white babies' parents go home. In other words, they're more likely to be found accidental deaths with white parents than it is with Black parents. And that because these are subjective determinations, right? It isn't like a toxicology report where a machine is spitting out a number. That's not what's happening. This is somebody using training and experience, and that's it, to come to a conclusion, often without a real empirical basis for that. So that's true with all junk science, and what things like arson investigation. And the thing about it, and this is also true about junk science, is that
sorry, Chris, if we could just go back to your bite mark for just a moment, because you spend so much time in the book on bite marks. Sure. I was particularly intrigued by the case of the confirmation of bite mark in an adult when it was actually a 3-year-old child that had bitten the victim.
That did happen in one of my cases, but that's not one of the cases in the book. What had happened, I think, is we're talking about LaVon Brooks and Kennedy Brewer cases in Mississippi, where it was actually mosquitoes or crawfish that ended up leading the bite marks on bite marks on somebody's body. Yeah. So all kinds of things.
No, it's okay then. It's okay. I may be getting my cases mixed up, but so you can just go on and talk about arson if you'd like.
Well, I explore arson and in 4 wrongful execution cases that I cover in the book, and one of them is based on bad arson, so-called science. And what I was saying before is that all junk science it appeals to your intuition. It makes a certain amount of sense. It doesn't sound like hogwash right out of the gate until you really start critically thinking about it. Like bite marks make a certain amount of sense. If I could find this and find the teeth, match that would, lead to find the perpetrator. With arson, because of this guild structure that we were talking about, the NFPLA was the main fire investigations organization, a lot of folklore had been built up for 100 years. Things like, so what they would do is a fire investigator goes into a burned building after the fire is over and tries to piece together what happened. And the received wisdom of the field had been for a long time that things like pour patterns. So you would see like a pattern on the floor that zigzagged across the floor. And it was believed that that was indication that an accelerant had been used, something like gasoline been poured on the floor and lit on fire, or lighter fluid, right? And you could see the trail. And there were also things like multiple points of origin of the fire, right? Suggesting that it's hard to have an accidental fire if it started in 4 different places, right? Sounds like somebody's doing that deliberately. I thought that something called crazed glass would happen in a fire that was deliberately started and used an accelerant, because the theory was that it burned much hotter than other fires. And so that would cause glass to become basically shatter and crazed. They had alligatoring on the floor was another indication of arson based on this folklore. And the problem had been is that there had never been any scientific experiments that demonstrated that was so, right? This was training experience, received wisdom, passed down from one generation of fire investigator to the next. And what I write about in the book was, it was incredible, really, is that is a death penalty case in Florida, Gerald Lewis, who is 5 people had died in a case that really did look like arson. There was like lots of, little circumstantial evidence that suggested that he might have done this. But there was also another and a very clear alternative explanation. And so it wasn't clear if they were going to be able to rely on the so-called science of arson investigation. And what they did was the first controlled burn experiment that they did. They replicated the house that had been burned down to the windows, to the furniture, to everything. And a fire investigator named John Lentini and another investigator put this whole experiment together, lit the building on fire, and went in and investigated afterwards. And they saw pour patterns, they saw multiple points of origin, they saw crazed glass, all these things in a fire that they know had not been deliberately set, right? They put like matches in a couch or whatever it was. So there was no accelerants being used. And so all these so-called indicators of arson turned out to be false, junk science, right? And the Cameron Todd Willingham undoubtedly was innocent, was undoubtedly executed just based on that type of folklore. So, that's and this is the problem with a lot of the forensics. If you don't have valid scientific experiments and publishing those data, then you get folklore masquerading as scientific evidence.
Looks like there's a lot of folklore that is being used to put people away, unfortunately. So the next area that you maybe, in popular wisdom, of course, we can do hair analysis. Can you tell us what's wrong with hair analysis?
Well, I can tell you that I read about this, my first week at the Innocence Project, the FBI, the Department of Justice, came to us and admitted, after using hair microscopy for a century and extensively in the post-World War II era, that hair microscopy had been misused and overstated and presented in false and misleading ways the entire time. And that was revelatory, because the FBI had never conceded anything like that before. And way too late. There had already been 70 known wrongful convictions attributable, at least in part, to the use of hair comparison evidence. And what's worse, and I'll explain why it's junk science in a second, is that, and something that I write about, is the racialization of hair microscopy testimony. And this is true in a couple other areas of forensics. And they have these kind of quasi-scientific sounding ethnic categories that they adopted in the 1950s and never abandoned still today. So they're calling these Negroid hairs, right? So what happened is, right around the time that the FBI finally admitted that, there were 3 Black men that were all wrongfully convicted of assaulting white women, all in Washington, D.C. All had been, hair microscopy had been used, and it was very important to the case. It all used this type of language. And you can imagine just how prejudicial it is in a rape case when you're playing on the same racist tropes from the last 400 years about the hypersexualized Black men and assaulting white women. So you have negroid hairs found in the pubic combings of the white victims, and that's like scientific evidence? No, it's not. It's junk science. It's incredibly prejudicial and racist. So that had happened, and the FBI was getting a lot of media pressure, and they came to the Innocence Project and the National Association of Criminal Defense Lawyers to conduct an audit of thousands and thousands of cases. And in more than 95% of them, false or misleading testimony had been given. And the reason is that they'd given all this testimony that suggested that human hairs are unique, right? And that everybody has different hair, and that they were able to distinguish these under a microscope. That's just not true, right? So, they don't have a statistical basis to make that claim, unlike DNA. The reason you get these astronomical statistics in DNA is because we've actually done the research that has a valid statistical basis to make those claims. That had never been done in hair microscopy. So we don't know how rare or how common these so-called microscopic characteristics were that they were matching together. So the claims were, that it was either the suspect's hair, or was very likely the suspect's hair, or they were using their own prior casework as a proxy for a valid scientific and statistical database, which would say something like, I've been a hair microscopist for 20 years, and I've never seen two hairs that matched, and suggesting that through their own experiment or their own experience that the hairs were unique. But we know that's not true. And we also know that nobody can keep a database in their mind of every hair that they've ever examined and compare one that they looked at 10 years ago. Oh, this one, I've never seen one like this before. It was nonsense. But they were never called out on it until a back-to-back exonerations and a lot of media pressure.
I think I'm torn in terms of the other areas, but I think the one that our audience may find intriguing is a shaken baby, because we tend to, these cases get shown on television and they're so dramatic, and you have the case of the British au pair who was accused, and I don't know what her status is now, but she was convicted of killing a baby by shaking the baby. So can you talk about in general shaken baby syndrome?
Yeah, there was Louise Woodward, who was represented
that's
by
right.
Barry Scheck, mentioned earlier. Shaken baby syndrome diagnoses was something that was a hypothesis that was developed maybe 30 years ago. And what it was is that you would have babies that had become unresponsive and died. And then what they would look for is three particular diagnoses: subdural hematomas, petechia in the retinas, and
something in the neck.
Well, no, they often miss those. But anyway, I can't remember what the third one was. But the point is that the theory was that the only way that this brain could have been injured and stopped breathing was that there had been violent shaking. But there was often no other indicia of abuse, right? So if you think, but there were no neck injuries, right? So if you're thinking about how you would actually do this, that you would have to have had a neck injury or grip marks on the arm, and that nothing like that was available in these cases. And then finally an experiment, or not an experiment, but there was a boy had died, and they had a videotape of a playground fall that the boy had about a day before. And what it showed was that this boy had fallen a relatively short fall, a couple of feet, hit his head, and was lucid for the next 12 hours and then died. And before that, it wasn't thought that short falls like this could cause an injury, have periods of lucidity, and then die. And so what we understand now is that these types of falls can lead to death, and it can be as much of a day later. So often the caretaker, who wasn't around even when the original injury occurred, is the one that is basically a hot potato, and that's the one who ends up getting charged with a crime. So there's been at least 35 known wrongful convictions, and as a result of shaken baby diagnoses. Very, very hard to prove, because there's been the shaken baby diagnosis has led to all of these wrongful convictions. And what's interesting is that the original progenitor of the theory has himself rejected it, and yet it's still being, used in court today.
Mary, do you mind if I ask a quick question?
No, I was gonna introduce you, Robbie. My colleague, Robbie Madrigal, Chris, would like to ask a question. Go ahead, Robbie.
Yeah, thank you, Chris. This is wonderfully illuminating. It's not in your book, but the case of Dean Cage, he was sentenced to 40 years in prison for allegedly raping a 13-year-old girl. And it was apparently a very emotional scene in court where she said, "He raped me." And she identified him by the sound of his voice. And I thought it was he was eventually exonerated. It was really heart-wrenching story that he served all this time in prison. And he said he was with his fiance at the time, and the fiance corroborated his story, but he was still sentenced to 40 years in prison.
I don't know about that case, but I have heard, so many cases like that. It's, there are a few things, and I have, sometimes I'll give this lecture to prosecutors in particular, but is that we have very vulnerable victims like children and sensational allegations. It's very hard for justice to prevail under those, particularly dealing with an innocent person, because people feel, understandably very emotional about a child victim or a rape victim, and that in very high profile cases where there's a lot of pressure to get a conviction. And so, any defense attorney will tell you that they're terrified of trying a case that involves a child victim or a dead baby or something like that. And that's why a lot of these shaken baby cases, particularly because, there's a bias against poor people and poor people of color. And so they go, and we talked a little bit about this earlier, go to the hospital, and there's this thought that this is a neglected child, an abused child, simply because they're poor, right? That they don't look as, kind of put together as like a typical white baby would. So when you're talking about junk science, you think about particularly the cases that I explore in my book, in Stephen Chaney's case, for example, the one that I read about, is he had 9 alibi witnesses, 9, right? Counting for every minute of the day from the entire day that crime had been committed until the next morning. He was 300 miles away. The junk science was enough to overcome it, and this is why we have to be so careful about what we admit as so-called scientific evidence.
Yeah, just, in American culture, and I'll share an example. When I posted an announcement about this lecture, I received an email saying, from an anonymous person, if you can't do the time, don't do the crime. So there's this perception that everyone in prison is there for a just reason, and clearly not the case.
Yeah, what was shocking to me, when I was a public defender, I was kind of used to wearing, the black hat in certain circles, right? That you were, how can you defend those people type of attitudes. What was shocking to me is that when I became an Innocence Project lawyer, how many adversaries we had, and I was like, how is it that, if you wake up in the morning and the Innocence Project is like your chief adversary, you've done something wrong, is that because we're trying to free the innocent, and we're trying to prevent wrongful convictions. So this notion that, that there's a, separate and apart from all, why we prosecute and who we prosecute and, in this system, which I think is a huge other topic, but you talk about innocence. And one of the things that I will say, and that people are always very surprised when I say this, is that most people who go to trial, who are indicted and go to trial, are guilty, right? Imagine we lived in a society where that wasn't so. Often they're overcharged and like factually innocent of many. There are lots of problems with those so-called guilty people, but most of them are guilty of something. But we have 2.3 million people in various forms of incarceration in this country at any given time. 2.3 million. So you're talking about 1% are innocent, right? And I think that's a very conservative number. There have been empirical studies that suggest it's 3 to 5%. But if you're talking just 1%, we're talking about tens of thousands of people. So the idea that you could just be dismissive about the innocence movement, is what it's often called, is belied by the numbers. There are, last year, I think there was something like, more than 100 exonerations in this country. It was just like, astonishing. And before we had DNA evidence, it was believed that, a wrongful conviction was a vanishingly rare event. That we're the best system in the world, right?
Mary,
I'm sorry.
do you mind if I read a question from the audience?
I just want to make a couple of more points, and then we can read the questions from the audience. Chris, I would be remiss if I let you go without you're saying something about Dr. Michael West, who stands above the horde when it comes to being an interesting character in this book. And I think you describe him very well. Would you mind just saying a few words about him?
Sure. Michael West is kind of the purest manifestation of the harm and how junk science facilitated this person's rise, and he was given all these credentials that we talked about and then took off with them. He was a forensic odontologist from Mississippi. He was very clever. He was very witty. He was really, really popular with juries. He had a huge ego. He, like so many forensic scientists, and became kind of a rock star in the 80s and 90s. He was on the Phil Donahue show. He was on Playboy magazine, Vanity Fair, many others. And he was the prosecutor's best friend. And he was great with juries. They loved him. They ate it up because he would mix up a lot of shucksums, that with a little bit of praise Jesus and liberal smatterings of scientific jargon. And he became kind of a pariah in the forensic community after the wrongful convictions of LaRon Brooks and Kennedy Brewer, both of whom were wrongfully convicted of capital murder and rapes of 3-year-old children. And he had kind of disappeared into the Hattiesburg swamplands for a long time. But when we were identifying all these cases, another Eddie Lee Howard in Mississippi came up. And when I was kind of tasked with, kind of eliminating bite mark evidence, through my new role, it felt like inevitable that I was going to end up in a confrontation with him at some point, kind of like Luke would have to confront Vader at some point because he was like the boogeyman. And so I did this, one of the scenes that I think that you're talking about, Mary, that I wrote about was a deposition that I took with him, which was really one of the most incredible legal experiences that I've ever had. I mean, it was hard to call it illegal, as a lawyer. I mean, but it was really just totally bananas. And, he called me an asswipe, and he called me Mr. Asswipe, accused me of being a sociopath. He lied, he dissembled, he had an unindicted co-ejaculator theory for all these cases that he had, which is something that I talk about. And this is basically invented new theories to explain away DNA evidence. And, in the transcripts of the deposition, which I'd never seen before, is that he's just sitting there, he's eating, during there's this big buffet, and he belches so loudly that the court reporter put it in the transcripts. Witness belches, right? I had never seen that before. It was like a stage direction. And it was just it was definitely to get even kind of a thing with him, because he's such a monster, it was just so yeah, it was a terrifying experience. It's kind of funny the way it reads, but at the same time, just remember we had a man on an innocent man on Parchman's prison farm's death row, which is literally a slave plantation all the way up until it was turned into a prison, and nothing has changed. It just became a prison as opposed, there's still slave labor, the same horrific conditions. My client, Mr. Howard, wouldn't even come out. Came from New York all the way down to the Mississippi Delta to go and meet with him. And he wouldn't leave his cell to come meet with me because he's terrified of leaving. So, and I talk about when he was finally released, he had to learn to walk again, taking full strides because he'd been in leg irons for so long, And so this is the kind of conditions that we were talking about. Michael West is this person that was being held up as a credible expert by the state of Mississippi. It was really hard to believe.
And who knows how many he's been responsible for putting behind And that's one of the things I like about your book, is that you always humanize it. You humanize the, the poor, people of color, victims of these so-called experts who are, and the way that they became experts is just so astonishing. That these folks who are, who could be selling popcorn in in a movie theater are now making decisions about people's lives. So Robbie, do you want to read a question from our audience?
Yeah, we just have one question. I know that we're
Okay.
Getting close to the end of the hour, actually, so 2:02. This is by student Tori Saka. This is amazing and terrifying at the same time. What evidence is considered scientific and not junk science? What can we rely on?
DNA.
Good question. Yeah.
Good question. Yep.
Yeah.
That's my answer for you. The high quality DNA evidence.
Yeah. I also thought that what you said about the three top reasons for wrongful convictions, which were surprises to me, actually. One of them, the first one is snitch testimony. And it intuitively, it doesn't sound like something that we should rely on, right? Because these folks are trying to get out of prison or whatever. Snitch testimony. The other is junk science. And then the last one is false confession. And you touched on that a little bit. And you also talked a little bit about the Central Park Five, their false confessions. I mean, like you said, these kids, they gave detailed information about what they supposedly had done. So unless there are any other, Robbie, did you have another comment or question?
No, I know that we're getting close to after
Yes,
2.
we are.
Okay.
Yes, we are. Yeah. Thank you so much, Chris. We all appreciate knowing how busy you are and the work that you're doing. We thank you for coming here today, of course, but the bigger picture is the work that you're doing and others are doing in the Innocence Project. And we should probably point out that there is more than one Innocence Project. I mean, they come under different names, but they're all over the country now, thanks to what you all started in New York.
Yep, that's right. There are 3 in California.
Yes.
And so thank you again for the invitation. I appreciate it. Feel free to reach out to me. I'm on Twitter at Chris_Fabricant. Anybody, I'm responsive to direct messages or what have you.
You mean you're going to stay on Twitter?
Oh yeah, I get, and there are lots of reasons not to. I wouldn't blame anybody for abandoning it, but yeah, I'm gonna hang in for now. We'll see how it goes.
Okay.
Yeah.
We'll look you up before we leave then.
Okay. Thank you all
Thanks
again.
so much, Chris, and best to your doggies. They turned out to be fine. We didn't even hear them. You
Thanks
take
again.
care.
Bye-bye.
We'll see you. Bye-bye.